सब्सक्राइब कीजिए हमारे YouTube चैनल शॉर्ट हैंड डिक्टेशन लीगल मैटर्स को और दबाइए इस बेल को ताकि आपको मिल सके हमारा वीडियो सबसे पहले और यह बिल्कुल फ्री है।
Ready, start. This reference to the full bench arises from a government appeal filed under section 417 of the Criminal Procedure Code against an order of the Sessions Judge Dhar acquitting the respondents of the charges under sections 304, 392 and 302 Indian Penal Code. The respondents were convicted under section 304 part 2 and an appeal filed by them against their conviction was dismissed by a division bench of this court on 5/12/1949. Honorable Judge delivering the judgment of the division bench concluded his argument in paragraph 11 in the following words: I would therefore maintain the conviction and dismiss the appeal. The learned government advocate made a strong plea for alteration of the conviction to 1 under section 302 of the Penal Code. The government has not filed an appeal from the acquittal under section 302, although such an appeal would be within time and in the circumstances. I would not think of altering the conviction, though I agree this court has the power in a proper case to do so. The government advocate then filed an appeal on 21/12/49 against the order of the Sessions Judge Dhar acquitting the respondents of the offences under sections 394, 392 and 302 as stated above. An objection was raised by Mr. Sanghi, learned counsel for the respondents, that in view of the decision of the division bench dismissing the appeal of the respondents against their conviction, the government appeal against the order of acquittal is not competent. Whether it is competent or not is a question referred to this full bench. Much argument has been addressed to us on the question whether the division bench which heard the appeal against the conviction of the respondents was or was not empowered to alter the conviction of the respondents to 1 under section 302 Indian Penal Code. If the bench was so empowered, it has been argued, and the bench did not consider it proper to alter the conviction from 1 under section 304 to 1 under section 302. The appeal against acquittal filed after the decision of the division bench should not be entertained. In other words, the first question for consideration is whether this court, sitting as an appellate court, is empowered to convert the finding of an acquittal into one of conviction. A mass of case law has clustered round the question, and at present it has given rise to considerable divergence of judicial opinion on the point. A number of cases were cited during the course of arguments, but as this question is only of subsidiary importance in the case before us, I shall avoid a detailed reference to all those cases. At one time, of course, there was a practical unanimity in the country on the interpretation of section 423 subclause 1 subclause B subclause 2 criminal procedure code, and the high courts in India were agreed that the conviction under appeal could be so varied as to include an offence about which there was an acquittal. After the decision of their lordships of the Privy Council in Kisan Singh versus Emperor 50 ALL 722, another view emerged stating that the Privy Council had approved the statement of law that the only way in which a finding of acquittal can be altered or reversed is by a government appeal. Sharda Prasad versus Emperor AIR 1937 ALL 240 and Jado Rahim versus Emperor AIR 1938 202. Stop.